All right, in this segment, we're going to move forward and start talking about the holding of the case and the court's reasoning. One kind of way that I look at the holding is to think about it as a combination of the actual decision in the case, the outcome, in other words, then those important operative facts and the court's reasoning. If the court is looking at a pure issue of law, remember, if it's trying to figure out what the rule should be or what the standard should be, then there won't be any operative facts as part of the holding, because those facts are irrelevant to determining first what the standard or rule should be. So with those three pieces in mind, let's take a look. The decision in this case is pretty straightforward. The IID claim is dismissed. So the court is stating that based on the facts of this case, no jury could possibly find that the conduct alleged was actually outrageous. The court seems to focus on a number of different facts. It focuses on the fact that here the plaintiff is both 78 years old, ill, and the defendant knows these facts about her. In other words, the defendant knows that she's susceptible to emotional distress when it acted to fire her. The court also focuses on the fact that here we have an employee, kind of the little guy, versus the entity itself, plus the corporate officers, who have a great deal of authority over her. And the court takes that into account. And then the court looks at kind of the nitty-gritty facts of the specific situation that she's complaining about. That is that she was locked out of the office when she was out of the office ill, that there was a sign posted on her door stating her termination, and that she found the situation to be pretty humiliating, thus the lawsuit. Okay. So what's the court's reasoning? How does the court work its way through the test for IID and specifically for outrageous conduct? After giving you that three-element test, the court pretty quickly tells you that it's only concerned with whether the facts alleged could be deemed outrageous by a jury. Then it looks a little bit more specifically at, well, what do we mean by outrageous? What is the court deemed to be outrageous in the past? How has the court defined outrage in the past? And here the court tells you that the definition of outrageous conduct is that which goes beyond all bounds of human decency, and that things like mere insults or indignities, threats, annoyances, etc. simply don't count. Now, this is one of those places where you should start to question the usefulness of this rule. Do you know what a mere insult is? Could you be able to distinguish an indignity from something that is truly outrageous? This is a definition. It's a somewhat helpful definition, but this is one of those cases where you should ask yourself whether you could take this definition and actually apply it to a future case and know what the outcome of that case should be. So moving forward with the court's reasoning, why does she lose? And why wasn't the defendant's action outrageous? The court tells you that, in fact, it looks at a couple different factors. It takes into account, and it's allowed to take into account, whether the plaintiff was particularly susceptible to emotional distress, whether the defendant abused its authority. And here the court looks at both of those factors and decides that both weigh in her favor, that she probably was susceptible to emotional distress based on her age and the fact that she was ill, and that defendants may have abused their authority, or at least that they had authority. It's a little unclear whether they abused it from what the court has written here. But the court tells you that both of these factors weigh in her favor, and yet she still loses. So continuing on with the discussion, the court says that it finds that although the defendant's conduct was inappropriate, it's a good legal word, the acts alleged here are, quote, merely insults or indignities, and she loses. Again, this should give you pause as to why the court is so sure that what happened to her is a mere insult or a mere indignity. We'd like to know more from the court about its reasoning, if possible. Sometimes the court doesn't say more. But here we're able to read between the lines a little bit and move forward. When you're looking at the court's reasoning. There's at least 3 different types of reasoning that a court can sometimes employ when it's justifying its decision. And the first is precedent. So the court might tell you explicitly or more implicitly that it's bound by or persuaded by previous court decisions, and that its decision has to be read in the context of earlier decisions where the facts were somewhat similar. And here, although the court doesn't tell you explicitly that it's relying on precedent, it really implicitly is. So one of the things you should look for when you're looking for reasoning that relies on precedent is a description of past cases. And here the court's giving you those descriptions, not textually laid out really nicely, but parenthetically. Still counts though, still a description of cases that came before. So when the court is defining outrage as something other than mere insults, indignities, etc., it cites to a couple different cases. This Van Steen case and the Fang case. And in the Van Steen case, the court notes that the previous court decided that Illinois courts have limited recovery to cases involving an employee suing for IID to conduct that is, quote, truly egregious. Again, not a super well-defined term, but it gives you a sense that the bar is set really high here. So if you're an employee suing for IID, you have to show something that's occurred that's really awful. The second case description actually is a lot more useful. There, the court is describing the Fang case, and in that case, the court determined that if an employee is suing for IID, they're not going to win unless they can show something like attempted coercion into a crime or sexual misconduct. So if you're looking at the facts of our case, in the context of this earlier decision, you can see why she loses. And that reasoning, that argument, is a reliance on precedent. The court might also reason via policy. And in a policy argument, the court usually says that stating in favor of one party advances some important societal goal, in that it encourages good behavior or it will discourage bad behavior. Policy arguments are usually not part of a trial court decision. You're much more likely to see a policy argument on the appellate court level, if at all. And here, as it is a trial court decision, there's no policy argument to take a look at. Lastly, a court might simply reason that the rule or the standard that's been set out, remember here our 3-element test, simply hasn't been met by the facts of this case. And that's essentially what the court has told you when it says that the acts, though inappropriate again, are simply mere insults and indignities. They don't go beyond all bounds of human decency, and therefore she loses. Anytime you see this type of scant reasoning, and I think it is scant reasoning because there's no real sense from the court of what exactly she was missing, you should look to see if there's a better defense, either through precedent or policy. And here, as we noted, I think the court's best defense for its decision is really that it's following precedent and that previous courts have already strictly limited the types of situations for which recovery would be possible, again, when an employee is suing for intentional infliction of emotional distress. Okay, so putting it all together, how do you articulate the holding of a case? Note that you can articulate a holding very narrowly, which means relying on the very specific facts of this case, or more broadly, with gradation in between. And frankly, I could defend any of these statements of the holding of the case. But there's pros and cons. When you define the holding of a case very narrowly, it loses its applicability to future cases. It loses the predictability of having an already established case, helping you decide whether future cases might win or lose. So here, when you define the holding of the case as being fired and locked out of an office doesn't constitute IIED, you're subtly suggesting that this case is applicable only to other cases in which a plaintiff has likewise been fired by being locked out of an office. And it's not very likely that there's a whole lot of those cases out there. On the other hand, when you define the holding of the case very, very broadly, and probably the most broad holding of the case is right here at the end, that frankly, quote, mere insults don't constitute IIED, it's not very useful. You can see that holding applying to thousands of cases, but missing its specifics, it doesn't really give future cases much of a sense to go on, much of that information it needs to decide whether to decide a future case the conduct is outrageous or not outrageous. So it's probably something in the middle is the best articulation of the holding of the case. I like this one quite a bit. Being fired in an embarrassing way doesn't constitute IIED. So you've stepped back a little bit from those very specific facts of the case and looked at the case in a little bit of a more global way. And you can imagine this holding being applied to future cases. As you move forward through legal practice, we're going to talk about when you might strategically define the holding of a case very narrowly or very broadly in an argument to the court. But until then, just understand for now that you have some options in how you articulate the holding of a case. Too narrow, not very useful. Too broad, not very useful. So you want to think about what is in between those two in terms of articulating the holding. Okay, what else did we figure out from this case? What else do we know beyond just that one articulation of the holding of the case? The extra information that's important, information that seems like you should be paying attention to, things the court stated, that's not essential to the actual resolution of the case, the actual outcome of the case, is often called dicta. And here we have two really pretty important pieces of dicta that we can pull from this case. The first is the court tells you explicitly that it can take into account the defendant's knowledge of the plaintiff's susceptibility to emotional distress, and further, that age and illness both count as indications of susceptibility. The court really didn't need to talk about all of that in detail in order to reach its ultimate conclusion here that IIED wasn't present, that locking someone out of an office isn't outrageous, but it nonetheless went through this reasoning, and so it's important that we have this as a takeaway from the information of the case. And then likewise, the court told you that it could take into account the defendant's abuse of a position of authority and that an employee presumably is under the authority of an employer. So those are two important takeaways that we might think of as dicta from this case. Okay, two last pieces here. One of the most important aspects of your case reading is to ask yourself whether you're satisfied with the court's reasoning. If, for example, the court is making an argument based on precedent, if the court is telling you because the facts of this case are a lot like the facts of the previous case, the decisions must align, you should ask yourself whether the facts of the previous case and the case in hand are really all that similar. So we know here that the court probably was relying on precedent when it cited to and described previous cases in which an employee tried to sue an employer for IIED. What I would like to know is whether in those cases the employee was also deemed to be susceptible to emotional distress and under the authority of the employer. Court doesn't give us those details, but those are some of the questions you could ask yourself. Again, if the court is telling you, as it does in this case, that the test, the elements simply weren't met, here the court tells you being locked out of an office is an indignity, it's a mere insult, that's not outrageous. Question whether you might have wanted to know a little bit more information. I certainly would like to know what the court had in mind as to what could be deemed outrageous, but here the court doesn't tell us that information. Finally, if the court is making a policy argument, if the court is telling you that it's deciding as it did because that has the desired social outcome, ask yourself whether that desired social outcome is really likely to occur given the decision in this case, or not. Okay, last thing. When you're describing the outcome of the case, when you're thinking about the outcome of the case, it's not enough to simply state, oh, the plaintiff won or the plaintiff lost. What you should be thinking about instead is whether there are any further proceedings that are going to take place in this case. So if you're at a trial court level and you're in federal court, so you're lucky enough to have a written trial decision, you want to be able to articulate precisely what's going to happen going forward. If there's a motion to dismiss, for example, and the motion to dismiss is denied, that doesn't mean the defendant has lost the case. It means the defendant lost that motion to dismiss, and the case will move forward. And in moving forward, the defendant might win at some other proceeding in the case. So be careful of the stark win or loss. If you're reading a court at the appellate court level, you're looking for one of kind of three decisions: affirm, in which the appellate court is saying that the trial court got it right and that the decision will stand. Usually that means the end of the case. Or reverse. If the appellate court reverses, it means that the trial court, judge or jury, got it exactly wrong, but the case is nevertheless done with that new outcome. Or what you'll often see is the remand in conjunction with either the affirm or the reverse. So you might see affirm in part, remanded in part, reverse in part, remanded in part. Remand means that the trial court has to do some additional work to figure out what the outcome of the case should be. Often a remand occurs when the appellate court decides that the trial court employed the wrong rule or the wrong standard, and the case is remanded so that the trial court can look again and can make a new decision based on a new rule, but that it's the trial court's duty to do that, and the appellate court's not going to do that for the trial court. So again, bottom line, when you're describing, when you're thinking about, when you're writing down the outcome of the case, make sure you do with enough specificity to know whether the proceeding is going to continue, whether there'll be further movement on the case.